Yes. Yes, Mr.
The list of citations. They have given the proposition.
Yes.
The first proposition is that statutory rules would take precedence when there is variance with the advertisement.
Yes.
That's for twofold, my lords. First is, my lords, that minimum marks has to be prescribed. Second, relaxation.
Yes.
Third, the method in which selection has to take place.
Yes.
But can I just show the facts in each case, because I don't want it to be distinguished on facts by any. The first judgment is Malik Mazhar Sultan, my lords.
Yes.
The fact, my lords, relevant fact is at internal page 6, para
Yes.
18 onwards, my lords. Para 21 is the yes, my lords.
Yes.
But in this case, also at internal para 6 at page 4,
Yes.
the recruitment notification was issued. Candidates had participated, para 6. Para 9, my lords, the age is varied, my lords. Relaxation of age is varied. Therefore, my lords, some of them were ousted.
Yes.
Therefore, writ petition came up. Para 21 at page 6, my lords.
Yes.
The present controversy has arisen as the advertisement issued by the Public Service Commission stated that the candidates who were within the age on 1/7/2001 and 1/7/2 shall be treated within age for examination. Undoubtedly, the advertisement, but the recruitment to the service can only be made in accordance with the rules, and the error, if any, in the advertisement cannot override the rules and create a right in favor of a candidate if otherwise not eligible according to the rules. Yes. The relaxation of age can be granted only if permissible under the rules and not on the basis of the advertisement. Yes. Let's kindly mark this notes. I'm saying this because if the rules say minimum marks has to be set,
Yes.
that relaxation can't be given by way of notification or otherwise. If the interpretation of the rules by PSC when it issued advertisement were erroneous, no right can accrue on the basis thereof. Therefore, the answer to the question would turn upon the interpretation of the rules. Yes. Therefore, my lords, my first submission is if the minimum marks are not set and they say we will not fix it, that would be counter to the rules, my lords. My lords, the second judgment, my lords, is at page 11. Para 2 are the facts. Internal page 11, para 2, my lords.
Yes.
My lords, the facts are noted to show, my lords, that recruitment notification was issued. The appellant therein participated.
Yes.
After the interview, my lords, he was ousted, my lords.
Yes.
Now, at internal page 15, para 14.
Yes.
14 and 15, the variance in the advertisement and the recruitment rules is noted, my lords. 14, 15. But for our purpose, page 19, para 27. Right, I'm not saying recruitment should go. All that I'm saying is it has to be brought in conformity to the recruitment rules. That's all that I'm saying. Para 27. Any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. Thus, looking to the qualification prescribed in the statutory rules, the appellant fulfills the qualification and after being selected for the post, denying appointment to him is illegal and arbitrary. It is well settled that when there is variance in the advertisement and in the statutory rules, it is the statutory rules which take precedence. That is all that I'm saying.
No, even assuming that if it is accepted, can it be cured?
Malad, all that I'm saying is, Malad, we challenged the process before examination was conducted. They will today have to prescribe the minimum marks. This is the qualifying mark, this is the relaxation, and redo the exam. That is all that is left. Malad.
No, even after the examination,
yes, Malad.
Now that valuation has to be done.
Yes, Malad. Now, Malad, it may not be permissible. They can't fix the minimum marks after the exam is conducted.
Yes.
Malad, we challenged it before the exam. Interim orders were resisted, Malad, saying that we will proceed. In fact, memo is filed that we will take these many dates to for evaluation. It is
then everything is again fresh only.
Oh, Malad, the only stage that has passed this examination is conducted. Yes. Now the clock will have to be put back only to that extent.
The problem is conducting the exam in itself.
Yes,
large number of candidates are there.
Malad, in fact, can I before then I'll short circuit the Malad, it can be given a closure, Malad, provided Malad KPCL would find a way to accommodate candidates, my lords, who were selected, who are today not selected. But the problem is this, my lords. These petitioners, my lords, in the earlier round of litigation were respondents, rather impleading, who were not allowed to implead themselves. These people were selected. As on 28 December, before this exam, they were all selected candidates. After 28 December, we are ousted from the selection process.
Why?
Because of the new exam and the results. No, my lord.
Now that new exams you have not participated.
We have participated, my lord. Before participating, the first petition was challenged. Subsequently, all of this has come. Now, my lord, after 28 December, we are ousted. Before 28, we were there. Now, my lord, those who are impleading, of course, my lord, they were our clients earlier. They were in the division. They said selection is bad. Now, my lord, they are contesting saying selection is correct. So ultimately, my lord, it's a question of what happened when. If a way can be found, my lord, where all of us can be accommodated, it will be given a closure.
Yes.
How, my lord, next judgment, page 21, my lord, is the Tej Prakash, para 52, internal page 53. Para 52, page 53.
Yes.
This is what I wanted to point out. Thus, in our view, the appointing authority, recruiting authority, in the absence of rules to the contrary, can devise a procedure for selection of candidates suitable to the post, and while doing so, it may also set mark for different stages, benchmarks for different stages of the recruitment, including written examination and interview. However, if any such benchmark is set, the same should be stipulated before the rules or advertisement inviting applications empower competent authority to set different benchmarks at different stages of the recruitment. Then such benchmarks may be set at any time before the stage is reached, so that neither the candidate nor evaluator examiner is taken by surprise. So before the exam, if it is not stipulated in the recruitment rules, minimum marks can be stipulated before the exam. Now, my lords, the challenge is, because before the exam they say we will not stipulate, my lords. My lords, the next judgment, my lords, is the most recent decision which your lordships would find at page 59. My lords, that is for the proposition, my lords, that executive memos cannot be relied upon, my lords. Their contention is we have given a go by to the statutory rules because by virtue of the executive instructions, it was given as a one-time measure. Yes. Page 69, para 39 at the very bottom. Page 69.
Yes.
We also note the argument regarding the General Administration Department's 2018 memo and 2021 memo. While these resolutions reflect a policy to grant weightage, they were executive instructions. The recruitment in question was governed by the statutory 2019 rules, which did not incorporate these resolutions at the time of the 2019 advertisement. The state cannot rely on executive instructions to override statutory rules that were enforced during the initiation of the recruitment process, especially to the detriment of the candidates who had no choice, so on, so on. So, therefore, my lords, my submission is these.
Yes.
The recruitment rules, my lords, cannot be given a go by, they have statute. My lords, in the reply statement, my lords, the respondents take one contention, my lords. I'll just point out the paragraph, my lords, that the recruitment rules have no statutory force, they are just executive instructions. Your lordships got the reply statement, my lord.
Yes.
In the reply statement, my lord, I'm sorry. Page 19, my lords, para 31.
Yes.
It is submitted that Cadre and Recruitment Rules 1997 do not have statutory force as they are not framed under any provisions of the statute.
No,
page 19, para 31. Reply statement.
Yes.
It is submitted that the Karnataka Power Corporation Limited Services cadre recruitment, probation, promotion and seniority rules does not have statutory force as they are not framed under any provision of the statute.
How that rule has been framed?
Well, they say it is by way of board has adopted a resolution and therefore these are the rules. Well, I have no difficulty, but without recruitment statutory rules, a public corporation cannot make employment to a public post. Well, in fact, this contention is rejected by the court on the earlier occasion.
Considered.
I'll just point out that the judgment of
Kalburgi. See that rule first.
Yes, annexure T.
Rule is framed without law.
Yes. Well, then it has to be completely ignored.
Yes. Where is that?
Annexure T, page number 161, 162. It starts.
Recruitment, appointment.
Full recruitment rules. These are the only things that were
Conditions requested appointment.
This was given under RTI. Therefore, this is all Manoj that we have.
Yes.
Page 161 under RTI.
No problem. Now this, how this rule has been framed?
Well, not under any specific statute or anything. Well, this is only for internal purpose. We have framed these rules.
No, is it that power is available for you?
Well, in so far as this concern, there's a direct judgment on this part saying that it is only an internal thing. It is binding on us. Now, what the crux of the matter is, this is the third round of litigation. Let him complete. Just one sentence,
No, all his argument is on the basis of this rule.
Correct.
If you say that this is not the rule,
no, this
has no statutory force, then his arguments are gone. Why do you want?
Therefore, that I'll produce that to your law.
Yes.
But their argument is, Malad, it has no statutory force at all. Therefore, it's not binding on anybody, Malad. Then the entire recruitment has to go.
Now, where is that this issue has been decided?
Yes, Malad. The other judgment which I gave, Malad, just Geeta Chavan, Justice Magdum's order of Kalburgi.
Yes.
Malad, I'll just take your lordships to the specific paragraphs, Malad.
Yes.
Internal page 19, para 24, Malad. In respect of the very recruitment, Malad.
Para 14.
Internal page 19, para 24. Malad.
Yes.
On the other hand, learned counsel appearing for respondent number 123 has justified the respondent's action in prescribing 150 marks as maximum marks for Kannada language test despite the provisions of the Karnataka Power Corporation so and so. The learned counsel contends that the C&R rules of KPCL, while governing the service conditions and recruitment processes of KPCL employees, do not have the force of statutory law. Rather, they are of a contractual nature, essentially forming an agreement between KPCL and its employees. As such, learned counsel argues C&Rs must be understood as a set of internal guidelines designed to govern employment relations, and their interpretation should not be subject to the same rigidity as statutory provisions. Learned counsel emphasizes 4.2 of the C&R rules. They again rely upon the C&R rules.
Yes.
Now, page 31. This is where the consideration starts. The court, para 40, rule 4.5 of the C&R rules of KPCL is extracted as under Kannada language examination.
Yes.
I read this out to you a lot.
Yes.
Now, my lord, after assessing all the arguments at internal page 44, para 57.
Para 44.
Page 44, para 57.
Yes.
The recruitment authority is obligated to set minimum qualifying marks in advance, providing clear and transparent criteria for all. The fixing of 150 marks as the maximum score, which is contrary to the regulations under, let's say, quote, KPTCL instead of KPCL. has further complicated the selection process. They rely upon the KPCL recruitment rules to say fixing of 150 marks is contrary to the C&R rules, which prescribe 100 marks.
No,
Now,
but,
47 Malad.
no, what they are saying that this is only a contract and it can be changed at any time. Therefore, now what they are changing, it is not contrary to that because it has no statutory force. That is what their arguments. I think so.
Malad,
Para 25, that is what your lordship, page 20, para 25 is exactly what was argued. Yes, page 20, para 25, page 20,
Yes. Yes. Para 25, yes.
25 specifically, the Learned Council emphasized that Rule 4.5 of the C&R rules, which may traditionally set out certain criteria for recruitment, should not be viewed as a provision that limits or rigidly governs the discretion of KPCL. Instead, it is argued by KPCL as the authority to modify or adopt its own internal recruitment process, as long as such modification serves the larger goal of administrative efficiency. The Council considers the decision to prescribe 150 marks as the maximum for Kannada language test falls well within the discretion of KPCL, and such change was permitted within the broader powers granted. This is what your lordships were pleased to just observe.
that is exactly what at page 44, para 57. This was the contention that statute, it has no statutory force, it cannot be relied upon.
No, they are not saying that. They are saying that
Yes,
they are making some regulations or rules.
yes,
They are adapting.
yes,
See, if there is a regulation and rules, they can change any time.
yes,
If it has a statutory force, that cannot be contrary to this.
yes,
They are saying that it may be called as a rule,
yes,
but it has not in a rule has any statutory force.
yes, Manoj.
It
Then
is as like now they have issued one more circular.
Yes.
Like that, this is also one of the circular. That's what.
Yes.
Is it be permissible under that?
Malad,
I don't
at
know.
any
We have to
time,
be-
yes, Malad. I'll point to that. Page 44, para 57, Malad. Quote first, fourth sentence, Malad.
Yes.
The fixing of 150 marks as maximum score, which is contrary to the regulations under the so and so, has further complicated the selection process.
Yes.
That is the finding, Malad. Their submission is it can be changed. Court says no. This is the criteria in the C&R rules. What you have done is contrary to that, which complicates the matter.
No, is it
Yes.
not permissible for them to change that rule?
It is, Malad. Absolutely. They have changed it as a one-time measure by way of an executive instruction. Now, Malad, that over. 2014, it was over. Then what prevails is only these executive instructions. I'm assuming it is correct. Even assuming these are only executive instructions, even then, the benchmark to set the minimum qualifying marks and to do a certain thing a certain way remains. That's page 47, clause D, Malad.
Just page 44,
Yes.
what? Just to so that
Yes.
we are on the same
Yes.
page. Page 44, para 57, Malad.
Yes.
Ultimately, the court has not gone. Just I'll read this one paragraph.
The court has not decided that aspect.
That aspect, and what it says, it is unreasonable. 5 lines from top. It is unreasonable to expect aspiring candidate to speculate about the minimum qualifying marks based solely on the maximum score of 150. If the respondent had properly notified the minimum qualifying marks in the recruitment notification, it is only natural the candidate would have been tailored the preparation accordingly, aiming to secure the prescribed 50. Furthermore, it is crucial to recognize the question of technical one and passing Kannada language exam should not override the technical qualification required to the part. The primary focus should be on technical competence of the candidate and imposition of arbitrary language proficiency requirement without prior notice to undermine the fairness of the process. Ultimately, Malad, here, Malad, there are to say there are around 600 posts, Malad, or now 429. Now around 19,000, approximately 9,000 or not. Every time an examination is being held, Malad, they're saying that ultimately what we have once we have cancelled because of malpractice. Second, court has set aside on 2 counts. One is Kannada and one is with regard to negative marking. While passing that order, court says go by your own notification of 2017. We have followed 2017 notification. Now, when we follow 2017 notification, there is C&R is not applicable.
No,
If
2017 notification have not prescribed passing marks for
No, my
technical.
No, my
Already.
lord. No. Therefore, my lords, if we had followed
No, then why that 2017 recruitment has been passed by that High Court?
Well, on 2 counts, Malas. One was independent, which this judgment saying that minimum marks for Kannada, Malas. That is one. Second thing, Malas, negative marking was not informed to them. Only on the same point, Malas. Prior knowledge is not there, they were not put on notice. On both Kannada and the earlier notice.
There is no answer for this, fixing a passing marks. There was no discussion on that.
No,
order.
And one, therefore, Malas, all I would say, Malas, just so that we can go.
No,
it's a constructive res judicata. You can, having followed strictly as per this judgment, we are not only bound by the earlier division bench judgment, which upheld by Supreme Court. Now you cannot take an argument which was not argued saying that follow C&R rules, not your 2017 notification, because this notification was there when that was argued earlier also.
So that contention you have raised and it is not.
No, therefore, as my learned friend fairly considered, once he has appeared for those people who are on this side, now he is appearing people who are.
I think it's not that. No.
He is an advocate.
No, I'm not saying. No, my point. No, I'm not on that point. Point is, out of 9,000 people for 600 posts, somebody will be agreed because they're not gotten. Ultimately, the idea is not to get the best candidate. As long as procedure quality is not arbitrary, they are put in prior notice of the nature of examination.
That what you are saying that earlier same notification was made there, it is considered by the division bench. There is no finding regarding that condition is wrong or.
Please, my lord.
But how will you operate for SC/ST that?
Insofar as SC/ST, it's a very normal argument. SC/ST minimum prescribed is then you have to give 5 marks. We have got 2 separate lists, Malad, for SC/ST separate list and general merit. So what the position is, if you are putting minimum, when only 3.3, when Viva is to be held. There is no question of Viva. 3.3 speaks specifically about when Viva condition
are making that SC/ST separate list.
Separate list itself, Malad.
That might
on the basis of merit, number of seats, vacancies, a separate list. Or whatever is there, it will be filled up. They are not agreed in that sense, Malad.
The merit there.
Yes, absolutely, Malad.
That might
so therefore, to saying that because we are not prescribed minimum, giving additional marks, nobody has failed, or nobody will not be getting.
If they are clubbing together, then relaxation will come.
Absolutely, Malad. About on your lordship.
It can't be, Malad, kept separate. The most meritorious candidates of a scheduled caste, Malad, by virtue of all the judgments, will sit as a general merit candidate. He can't be segregated and kept only in a scheduled caste category, Malad.
That is for filling up.
Yes, that is.
Therefore, not for two, no. Malad, see, they will give a marks.
Yes, Malad.
See, scheduled caste candidate who has secured in the top.
Yes,
if he is secured more than that general category, he will come to the general category.
But they are keeping it separate.
Person who is below, in that he will come to the top.
Yes, but they are keeping it separate, even by their own admission.
No, ultimately,
yes,
whether it will affect that larger effect, nothing will be. Their right has been protected. That's what the.
Malad,
let us see that how they will answer.
Yes, Malad. Malad, even otherwise.
Yes.
Malad, one is the earlier judgment, Malad, of Kalburgi, Malad, the direction at page 57. 51, Malad.
Yes.
Kindly have a look at clause 3, Malad. The respondents are directed,
yes,
to reconduct the Kannada language test, ensuring compliance with Rule 4.5 of C&R rules.
Yes.
By prescribing minimum 100% marks, 100 marks to the test. Now, Malad, admittedly, the court has said you follow 4.5 of C&R rules. Today, they can't say, Malad, it has no statutory force, I need not follow it. Malad, assuming that argument is also correct. Malad, today what is held against me is constructive res judicata. Same should apply to them because before the division bench, they did not say these are no statutory force. Retest is because of the division bench, Malad. Oh, division bench gives a specific finding. In the absence of negative marking in the rules and in the notification, you can't have negative marking. There they did not raise a contention that rules have no statutory force.
No, court said that you can't have any negative marking.
In the absence of the rules.
Now that has been removed now.
No, I'll point out the finding, Malad. Court specifically said, in the absence of negative marking in the rules, you could not have prescribed it. I'll point out that, Malad.
Yes, where is that?
Malad, yes. Malad, 3 points were raised for consideration. I'll just take your lordships to those. Para one not, I'm sorry, Malad, in that petition, that your lordship. The writ petition 2328.
Yes, 2328.
Yes, ma'am. 3 questions were framed, my lord, which your lordship would find at page 121. My lord, internal page number 31 of that judgment, my lord, which is at page number 127.
No, this is division.
Yes, ma'am.
Yes.
Yes. The 2328, that would internal page 31 of the judgment division. Can I read from the top?
Yes.
The contention advanced by respondent number 1 KPCL that the condition applies by implication is untenable for multiple reasons. Firstly, negative marking was imposed only through admission ticket and question booklet of the 2000. It is neither prescribed in the rules, regulations, nor in the recruitment notification. Moreover, the admission ticket and question booklet cease to have effect upon completion of that examination. Here, my lord, they never said that rules have no statutory force, I don't have to prescribe it. When the court gave a finding, when it was argued that the rules specifically, my lord, I'll place, in fact, my writ appeal is here. I have taken a specific contention that the rules do not prescribe negative marking. My lord, they did not say rules have no statutory force, I don't have to prescribe. If today what is held against me is constructive res judicata, that this was not argued earlier, then, my lord, their contention that this has no statutory force can't be looked into.
Yes.
My lord, in fact, the judgment of the Supreme Court also makes a reference to that.
What is that final order of the court?
Final order of the court was, you did not prescribe it before the exam, you can't prescribe negative marking after the exam. Now, my lord,
So that means to say you can prescribe
before the exam. That's all that I'm saying.
Court said, if the rules doesn't prescribe, now you can't do it.
Yeah, that is why they said, my lords, if the rules don't prescribe, then you can prescribe it in the advertisement notification. If you don't prescribe it before the stage is crossed, you can prescribe it. But after the stage is crossed, you can't prescribe it. Now, my lords, here in this case, the recruitment notification does not talk of minimum marks. The 3.3 talks of minimum marks.
Now you will come to that final directions order of the court.
Roman 4.
Yes, operative.
Yes.
Page 124.
Yes. 143.
Yes, ma'am.
Yes.
120. I'm so sorry. Yeah, 143.
Yes.
The order of the learned single judge in writ petition so and so are set aside. The notification bearing number so and so, the final score list dated so and so, and the provisional score list are quashed. Respondent number so and so are directed to conduct re-examination expeditiously within a reasonable time for all candidates appeared in the examination on so and so pursuant to the notification. Re-examination shall be conducted subject to the condition of negative marking, and such condition shall be expressly communicated. That is all. It was only on the question of negative marking, my lords. Court never said don't follow 3.3 or don't follow. My lord, if your lordships were to...
On 3/8/2017,
yes,
there was a condition that they are not prescribed passing marks.
No, my lords. They never said they will not do it.
That has been upheld court only in respect of that negative marking. They said that you first integrate and do it.
Can I put it this way?
Yes.
2017 notification never spoke about minimum marks.
No, it is not there in that.
No, it did not say we will not prescribe at all.
Where is that 2017 notification?
My lord, annexure B, my lords. Page annexure B, page 50. Your lordships may see, my lords. Page number 43, my lords.
Yes, you got it. Where is that?
My lord, clause 6 is the selection procedure.
Yes.
The recruitment notification is silent about minimum marks. There was no minimum marks that was prescribed. It can be prescribed before I write the exam. Now, when I am writing the exam this time.
No, that earlier, what was their understanding then in the selection? If there is not prescribed.
Yes, my lord. They can prescribe it before the exam in terms of the recruitment.
That's not that.
Yes,
now, what you will do that in earlier notification for examination is concerned?
It was first time it was cancelled.
Minimum prescribing marks when read 3.3. What my learned friend is not telling is only when there is mandatory viva. It is written examination and viva. That is why they say that you have to get minimum passing marks, then only you will be eligible for Viva. But in 2017 notification, when all of these students who wrote the exam, they never were agreed by this notification saying that minimum marks is not prescribed, it is contrary to C&R rule. They never argued that. They are happy with that. Now, having
I understood that what you want. Yes. Yes.
I'm sorry, Malad. Viva is never a criteria for selection, Malad. T1 page 170
Selection will be made purely on the merit basis, duly following reservation policy. Merit list will be prepared based upon the marks obtained in the written test.
Yes, Malad. Page 177, Malad. Your Lordship's mercy. Only for written test.
Yes.
177 is the amended rules which were in force. It did not prescribe any Viva votes. It only said qualifying exam, and that's page 177.
No, earlier also, there is no passing marks for written test.
Yes, it can be prescribed before the exam. That notification need not prescribe it at all. That is where, Malad, I read Tej Prakash.
Even examination is not conducted there. Before that,
Malad, it was conducted, cancelled. Second time conducted.
Is there prescribed before that examination?
No, Malad.
Then earlier also there is no.
Yes, Malad. Now kindly come to page 177, Malad.
Yes.
The amended rules.
Yes.
These are the amendment. For the written test to be conducted, MB will nominate the authority to conduct the written test. Specify the minimum pass marks for general category with relaxation.
Yes.
This clause, this portion of the clause is retained. What is amended here is, instead of Viva voce, there will be a qualifying exam and a written test. That is all that is amended.
Yes.
Malad, their contention is, in the earlier time we did not prescribe, therefore we need not prescribe, Malad, may not hold water, because when the retest is being done, it has to be done in accordance with these rules. Now to say, Malad, these rules have no statute.
But division bench said conduct in terms of that notification dated so and so.
No, Malad, conduct pursuant to the notification.
Pursuant to that notification means same. Except changing in respect of that negative marking, all other things has been upheld till Supreme Court.
No, all other things were never an issue before the court. All other things were never an issue, because when the calculation of the marks itself was wrong.
But nobody is agreed for that passing marks.
Malad, we are agreed.
No, last
because
occasion
everybody is selected now, Malad, without any passing marks. Now, Malad, without a passing mark, everybody, Malad, what happens is, Malad,
then they will take on merit.
Malad, it can't be done that way, because minimum marks will have to be prescribed. Malad,
yes. You have argued on that. Why that if it is clubbed together, if minimum marks is not fixed, then it will affect that reservation.
Yes.
Now they are doing to separate this thing.
Malad, that my respectful submission is, Malad, that is even the recruitment notification or the rules don't prescribe for separate. One. Malad,
ಅವ್ರಿಗೇನು ರೂಲ್ಸ್ ಇಲ್ರಿ ಅವ್ರು ಹೇಳ್ತಿರೋ ಪ್ರಕಾರ they can do.
Then recruitment can't go on. Please have a look at this, Malad.
Yes.
In the entire
what they are saying, notification itself is the rule for them. Malad, when there is no prescribed rules, what is the notification which is, this is the rule, if you are agreed, you can challenge that. That is what that
Malad, then the earlier direction of the single judge to follow 4.5 of the C&R rules. Malad, they have not challenged this, where they said that you follow this.
Division bench.
No, Malad, this was not carried to division bench.
Which one?
The Kalburgi bench.
No, that is there.
There was a direction to follow C&R rules.
Yes. No, they said condition in that. See, if you use the word C&R, they immediately strike that it has a statutory force. Yes, they use that C&R, but it is their circular. You take it as in a circular, according to them, unless they have to satisfy the court. What they are saying.
Page 51 of the judgment, they say you follow this rule, C&R rule 4.1, you follow.
Yes.
Malad, they don't challenge that. Now they can't say I will follow 4.1 and forget the rest.
That is for them. See,
yes, I'm just answering
their court said that this is the circular, you follow it. If they want, they can pass in another circular and make it amended. But they want to follow it. Therefore, they have not challenged that.
Yes, it's the same circular. 4.5 and 3.3 are different portions of the same circular.
See,
yes, and
yes, if it is in a statutory rules, C&R,
Yes, my lord.
they can amend any part of that C&R procedure has been prescribed.
Yes, my lord.
Now they are saying that it is in a circular, it has no statutory force.
Yes, my lord.
If any other notification is issued,
Yes.
it is superseding earlier. That's what they are
Yes,
saying. Because that has no statutory force. That is what the arguments of the
Yes, my lord. But there is no
Advocate
other
General will
notice.
see how they will.
There is no other executive order rescinding these amended rules, my lord. They are
That is
called
not
rules.
that-
I can.
yes,
Yes. My lord, my other argument of Hyderabad-Karnataka, my lords, 2 separate exams have to be held.
Yes, that's you.
That is the second argument, my lord.
Yes.
Both the circulars,
Yes.
2016 and 2025, which they say they will follow, prescribe 2 different set of examinations.
Yes.
That
which
can't be
is,
continued.
which is that?
My lord, annexed Z and Z1, my lord.
Yes.
The very last notification,
Yes.
page number 234. Can I draw your lordship's attention from 233 onwards?
Yes. Yes.
I'll complete, my lord, in the next 5 minutes.
Yes.
233 onwards.
Yes.
Lord, 233.
Yes.
ಮಾನ್ಯ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ದಿನಾಂಕ 23/9/25 ಆದೇಶದಂತೆ ಎಇ ಜೆಇ ಕೆಮಿಸ್ಟ್ ಮತ್ತು ಕೆಮಿಕಲ್ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಾತಿ ಈ ಕೆಳಕಂಡ ಮಾಹಿತಿ ಆಗಿದೆ.
Yes.
No, my lord, they specifically 10/12/25, my lord.
Yes.
Clause 3.
Yes.
ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ 3625 ರಂತೆ ತಯಾರಿಸಲಾಗುವುದು.
Yes.
My lord, we objected to it. My lord, just take clause 3, my lord. ಆಯ್ಕೆ ಪಟ್ಟಿಯನ್ನು ಸರ್ಕಾರದ ಸುತ್ತೋಲೆ ಸಂಖ್ಯೆ 3625 ರಂದು ತಯಾರಿಸಲಾಗುವುದು. Now, if your lordships were to
That
see
you read that whatever it has been happened for that.
yes, my lord. For if
Have
it
to
is
have-
already one exam is done, it's all right. You prepare it in that manner. Last portion.
Yes.
ಮುಂದುವರೆದು henceforth you shall conduct 2 exams. Once they say, my lords, that they will follow this, they have to follow this.
Yes.
Right? And for this there can't be constructive res judicata because they say 3625 is the circular that we will follow.
Yes.
And that was published in 10/12, my lords.
Yes.
10/12 and 24/12.
Yes.
At least to that extent, my lord, I am entitled to such. That's my.
Yes, Mr. You also let him finish, and what is that on Kannada I will also say. Yes. Which is your repetition, Mr.
So 953 of 26, no? 953 of 26.
Yes.
In the morning, my lord, I have passed on the
Yes, yes.
synopsis, my lord. With kind permission, my lord, I will argue on the basis of this synopsis
Yes.
first to cut short the. My first submission is, my lord, of 2-fold, my lord. The Kannada examination, which is conducted by the KEA in consultation with the KPCL, my lord,
Yes.
is wholly impermissible in view of the judgment rendered by the Geeta Chavan case, which has attained finality and the examination was held
Yes.
according to the Geeta Chavan case. And that was not ever, at any point of time, that examination was not an issue before this honorable court after Geeta Chavan case.
Yes.
Why? Because, my lord, you will kindly see the events, my lord, which led to filing of the Geeta Chavan case.
What is that? Where is that Geeta Chavan case?
Annexed here, you will
You have it produced in this.
I have produced the Geeta Chavan judgment, my lord. Kalburgi judgment,
Kalburgi court justice
other-
119, my lord.
1-1.
119 in my writ petition, my lord. My writ petition, I have filed annexed D, my lord.
Copy he has given.
Yes.
Yes.
The issue was there, my lord, why they permitted to hold the Kannada examination, my lord. At page 51, my lord, the lordship will get point 3, my lord. The order, your lordship got it, my lord. Final order, my lord, of Geeta Chavan, my lord.
Yes. Conclusion.
Yes, ma'am. The writ petition is allowed the impugned endorsements while annexure Q and Q1 issued by the respondent number 3 are hereby quashed.
What is that endorsement?
I'll produce that endorsement.
Q1, what
I
is
have
that?
appeared in that.
Yes.
Ajay and myself appeared.
Yes. The respondents are directed to reconduct the Kannada language test, ensuring compliance with Rule 4.5 of the C&R rules of KPCL by prescribing a maximum of 100 marks for the test.
Yes.
Now, according to the KPCL, my lord, they held the examination.
Yes.
After this order was made, in terms of, my lord, 4.5 of the CN rules,
Yes.
on 4/2/2025, my lord. On 4/2/2025, in my synopsis, page number 3, my lord.
4/2/25.
Yes, my lord. Conducted the said examination in the descriptive mode, my lord,
Yes.
and which is valid, and till today that examination was never challenged by any of the candidates, my lord. So my humble submission is, examination results of this paper were never in question at any point of time. Therefore, whatever orders that are made by the division bench and also the Honorable Supreme Court are not applicable to the Kannada examination. This is my first submission. Kindly see the orders of the division bench.
No, that what was the notification earlier in Kannada examination? Where is
Yes,
the notification?
they have same notification, Lord, which was subject matter of division bench.
No, that's what notification in respect of
These
Kannada
two,
exam.
12/6/2024 and 18/5/2024 are the score list notifications, my lord.
No, how that examination has been conducted for Kannada? What are the conditions?
Conditions, I will tell you. Notification is there, my lord. Annexure A, my lord. Your lordship, you kindly see, my lord. Annexure A, my lord.
2017.
Yes, my lord.
Hmm.
3/8/2017, my lord. There, my lord. Your lordship will get at page 35, my lord. Page 35,
Language.
written test, my lord. Kannada language test. Those who have not studied Kannada as one of the subjects in SLC or equivalent examination are required to pass a Kannada language test. Candidates who pass the Kannada language test are only eligible to be considered for selection process. Date and venue of Kannada language test will be published separately in KPCL website. Now, sum and substance of this is, my lord, that in terms of the recruitment notification, the C&R rules, they have to hold the Kannada examination test in terms of the SLC standard, my lord. That means descriptive in nature along with objective in nature, my lord. 3 times, my lord, earlier to this examination, 3 times they held it in a descriptive mode along with objective mode. Therefore, suddenly, as on today, my lord, when they have OMR, suddenly they have turned it into OMR. Out of 100, they are entirely 100 marks they are prescribing as objective test. That is also bad. This is second ground of my attack, my lord, on the Kannada exam. Kindly see the division bench order now, my lord. Whether the division in its entire order, my lord, has made any observations regarding the examination that is held on 4/2/2025. That is the examination regarding Kannada examination after the Geeta Chavan case.
No, that will come to that order portion.
Yes, ma'am. The writ appeals are allowed, 115.
Exam shall be conducted subject to that condition of negative marking.
This will hold, my lord. Your lordship, I will just clarify the facts and the dates so that my argument that the division bench has not at all prescribed any examination in Kannada, how it is emerging from the dates, that is very much visible.
We'll see what is the direction.
Yes, ma'am. The direction is the third point, ma'am. Third point, your lordship, may kindly see, my lord. The notification bearing number so and so, final score list dated 12/6/2024 and the provisionals of score list dated 8/5/24 are hereby quashed. They have not quashed, my lord, the Kannada examination held on 4/2/2025 because it was
this provisional selection list is prepared on the basis of that.
Not on the basis of the previous examination, my lord.
Yes.
The examination which was held prior to, my lord, 4/2/2024, there was one more Kannada examination that was quashed. So that after quashing that, my lord, these notifications have been. Third direction. What they are saying is, my lord, respondent number 1 to 3 are hereby directed to conduct a re-examination expeditiously and within reasonable time for all candidates. This all candidates they are interpreting as if all the candidates who are in the selection list. I have no grievance about it, my lord. All the candidates who are in the selection list has to write which paper is the question, my lord. The which that re-examination expeditiously and within reasonable time for all candidates appeared in the examination on 18/2/24 pursuant to the notification dated 3/8/2017. Now there is one more
Candidates appeared in the examination on
18/2/2024. On 18/2/2024, your lordship will get who are the candidates appeared for which exams in my rejoinder, my lord, at annexure H, my lord, page 17. I have filed, my lord.
Kannada examination has been conducted separately.
Separately, it was there.
On 4/2/25 it has been conducted.
Yes. This was never an issue before the division bench, never an issue before the Supreme Court. Holding examination regarding Kannada examination, that too in an objective mode itself is a null and void, is my humble submission, because that was not an order passed by the division bench. Why? Because
What is the directions of the
18/2/24, your lordship kindly excuse me. What are the papers that all the candidates?
What is that Gulbarga bench direction?
The Gulbarga Gita Chavan case, my lord.
Roman 3.
Page 169, my lord. The direction is, my lord. I will just read the third direction, which I have already read, my lord.
Yes.
Fourth direction, my lord.
No, the respondents are directed to
Reconduct the exact Kannada language test, ensuring compliance with Rule 4.5 the C and rules of KPCL by prescribing a maximum of 100 marks for the test.
Then Kannada examination also they are directed to.
That is already over, my lord. This division bench order was complied by the KPCL separately on 4/2/2025.
No, this on 12th December 2024.
This division bench order was not challenged before the Supreme Court.
Division bench order. This is single.
It is single judge. I'm sorry. This is single judge judgment.
No, after this Kannada examination has been held.
Yes. It is over, my lord. It is over. 4/2/2025.
No, they have held in terms of that rule 4.5.
Yes, my lord. We have no grievance, my lord. As far as that result is concerned, I have produced that result also.
No, by taking advantages of division bench, again they are
They have held the Kannada examination, which is wholly impermissible because nowhere, none of the candidates, my lord, who are party to the examination that is written on 4/2/25, they are not before the division bench, nor there is a direction to hold the examination regarding the Kannada language. That too, where there is no specific order to hold it in a objective manner. There are two aspects of my argument, my lord. If your lordship, first is that there cannot be any Kannada examination at all. There cannot be.
The same petitioner has filed a writ appeal against the judgment also.
No,
which is pending. You should tell that.
Yes.
There was no stay, my lord. I cannot say that because of that, my lord, I am precluded from arguing the validity of the judgment. No, I will inform. Sorry, my lord. Senior.
Go on, withdraw now.
I will withdraw, my lord. I will withdraw. Much water has been flown. Now that I will withdraw it, my lord. I will withdraw.
What is the second?
No, kindly see, my lord, this annexure E, my lord, after what happened, Gita Chavan, my lord, Gita Chavan, the second limb of argument to hold, my lord, that it cannot be in a objective type. Annexure E, my lord, my lord will get it, my lord, page 170, my lord.
Yes.
Here, my lord, the first Suchane nodadre, ಕನ್ನಡ ಭಾಷಾ ಪರೀಕ್ಷೆಯು SSLC ಹಂತದ ಪರೀಕ್ಷೆಯಾಗಿರುತ್ತದೆ ಹಾಗೂ ವಿವರಣಾತ್ಮಕ ಪರೀಕ್ಷೆಯಾಗಿರುತ್ತದೆ.
ವಿವರಣಾತ್ಮಕ ಅಂದ್ರೆ
descriptive long answers. Now kindly see the present and next annexure E1, annexure
only objective type.
Now objective type. At that time, when the Gita Chavan case was rendered, this is the mode of examination, and based on that, my lord, Kannada examination conducted, and the results are at annexure E1, my lord. What 171?
Yes.
My humble submission and my argument is that whatever may be the examination regarding technical papers, they have to redo the technical paper examination and add these marks, my lord, these 171 page annexure E1 Kannada results to that, and announce the selection list, because it changes the whole game altogether in two aspects, my lord. One is They themselves have conducted all the Kannada examination throughout whatever notification they have made from the beginning till now in a descriptive mode.
Yes.
Having understood the examination as per the C&R rules as a descriptive mode.
Method they are adopting.
That is also very OMR sheet, my lord. Your lordship will get it. I have produced that notification also. At page 102, my lord, the notification is there. Annexure F, my lord.
Yes.
And at page 203, clause 4, my lord. Clause 4, my lord. Page 203, my lord. Clause 4, my lord. Lordship got it, my lord?
Yes.
ಮೇಲ್ಕಂಡ ಮರುಪರೀಕ್ಷೆಗಳನ್ನು OMR ಮಾದರಿಯಲ್ಲಿ ಆಪ್ಟಿಕಲ್ ಮಾರ್ಕ್ಸ್ ರೆಕಗ್ನಿಷನ್ ಬೇಸ್ಡ್ ನಡೆಸಲಾಗುವುದು. ಅಂಡ್ ಇದರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ, ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನವಿದ್ದು ಪ್ರತಿ ತಪ್ಪು ಉತ್ತರಕ್ಕೆ 1/3 ಅಂಕಗಳನ್ನು ಕಡಿತಗೊಳಿಸಲಾಗುವುದು ಅಂತ ಹೇಳ್ತಾರೆ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ಕನ್ನಡ. One more mistake what they have done is annexure F1, my lord. After stating this, now they are telling that ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನ ಇರುವುದಿಲ್ಲ. At the top, my lord, your lordship will get ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ. Annexure 203, my lord, page F1, ಫಸ್ಟ್ ಒನ್, ಭಾನುವಾರ 28/12/2025 ಮಧ್ಯಾಹ್ನ 3 ಗಂಟೆ ಆದ್ಮೇಲೆ ಲಾಸ್ಟ್ ಕಾಲಮ್, ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನ ಇರುವುದಿಲ್ಲ. That means no negative marking.
Yes.
On the one hand, they say, my lord, that it will be objective.
Where you are pointing out
that 203 is the ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನ ಇರುವುದಿಲ್ಲ. ಅದಾದ್ಮೇಲೆ 203 ಅಲ್ಲಿ ಕ್ಲಾಸ್ 6, my lord, ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನವಿದ್ದು ಅಂದ್ರೆ ನೆಗೆಟಿವ್ ಮಾರ್ಕಿಂಗ್ ಇದೆ ಅಂತ ಒಂದ್ ಕಡೆ ಹೇಳ್ತಾರೆ. ಇನ್ನೊಂದ್ ಕಡೆ ಎಕ್ಸಾಮಿನೇಷನ್ 2 ದಿನ ಇದೆ ಅಂದ್ರೆ ಋಣಾತ್ಮಕ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. ಇಲ್ಲಿ ಮೇಲೆ F1 ಅಲ್ಲಿ ನೋಡಿ, F1 203 ಬಾಕ್ಸ್ ಅಲ್ಲಿ 204, ಐ ಆಮ್ ಸಾರಿ 204 ಬಾಕ್ಸ್ ಅಲ್ಲಿ OMR ಉತ್ತರ ಪತ್ರಿಕೆ ಮಾದರಿ ಋಣಾತ್ಮಕ ಮೌಲ್ಯಮಾಪನ ಇರುವುದಿಲ್ಲ. ಗಾಟ್ ಇಟ್ ಮೇಲೆ
ನಿಮಗೆ ಎಕ್ಸಾಮ್ ಇದು ಲೇಟೆಸ್ಟ್,
ಬಟ್
ಅವರು ಏನು ಅಂತ ಅಂದ್ರೆ ಎಕ್ಸಾಮ್ ಹೋಗಕ್ಕಿಂತ ಮುಂಚೆವರೆಗೂ ಅವ್ರು ಏನ್ ಬೇಕಾದ್ರೆ ಚೇಂಜ್ ಮಾಡಬಹುದು.
ಅದು ಮಾಡ್ಲಿ. ಐ ಆಮ್ ನಾಟ್ ಆನ್ ದಟ್ ಗ್ರೀವೆನ್ಸ್.
The petitioner doesn't have to write Kannada exam. He is actually about for somebody else.
No, I am.
He need not write Kannada exam.
No, he has not. No, what I am trying to say is, my lord, from the beginning, my submission is that I have already passed SLC examination. I need not write the SLC, the Kannada examination. But the very selection process takes away my right for selection because of wrong process. I am aggrieved by that.
See, you are the candidate who has taken a Kannada examination.
I am not the candidate.
Person who are happy.
No.
Examination. Why do you worry?
Why I am worrying is, my lord, my worry is this to this extent. No. What the reason is this, my lord. Kindly, my lord.
No, they want this type of examination. They are happy. Person outsider, why do you want to question?
No. What I'm trying to question is, my lord, because of this process, my ranking, which was at serial number 9, I have now taken out of the list, because at that time, those who wanted to get eligibility by writing Kannada examination were very few candidates. Now, because of this objective type examination, lot of outside state candidates have entered into, and they have pushed me down the list. I am not able to be selected because of this examination, Kannada examination.
For you merit, they have conducted an examination. You score it, go top. Don't take that others who will be scored top and he will come to effect you.
No, the very wrong process which is adopted by the
person who was affected has to be challenged.
The KPCL method is taking away my rights to be selected is my humble submission.
Yes.
Secondly, my lord,
yes.
Lords may kindly see, my lord, the
Yes.
The notification which the division bench has caused, my lord, dated 12/6/2024 and 8/5/2024.
Yes.
Already, otherly, there is no question of holding any Kannada examination, my lord, because they cannot make use of that for the purpose. Whether holding of Kannada examination is permissible, if it is permissible, then only whether it is objective or descriptive will arise. My submission is because the direction was only with regard to negative marking on the technical subjects. At no point of time, this examination result, which was announced on 4/2/2025, was not even a subject matter before the division bench, before the Supreme Court. For the purpose of, my lord, just conducting the examination, it cannot be held, is my humble submission.
Yes.
Then, my lord, Lordship may kindly see the Hyderabad-Karnataka reservation issue. Now,
You are also challenging that.
I am also challenging it because the non-Hyderabad-Karnataka candidates are now fitted into non-Hyderabad-Karnataka candidates category also. Because of that, my lord, I am ousted by Hyderabad candidates who are present, my lord, in the recruitment.
Your ground is also that there cannot be one examination.
That is one. Second ground is earlier, my lord, for Hyderabad-Karnataka candidates, they are permitted to apply under only that category.
Yes.
And they are not supposed to get selection under non-Hyderabad category. Now, that option was there. Even if they apply by using the option regarding Hyderabad-Karnataka, first they will be selected under the non-Hyderabad-Karnataka merit list. If they are not available there, then they will be selected under the Hyderabad-Karnataka list. That means what? That means a candidate who is not willing to come under the non-Hyderabad-Karnataka category, they are forcing him to come and take away an eligible candidate who has got a selection criteria under the non.
There is no forcing to come. If you don't want to come to that residual category, he can go back.
No, there is no such. They have taken out that option, my lord.
Principle has been considered in that reservation matter.
Ah.
They can be first given option to the general merit. If they want to still wants to there in that Hyderabad-Karnataka region, they can opt it and go there.
Now that, my lord, they will be selected under the non-Hyderabad-Karnataka category.
Yes.
Earlier, they are not willing to come here because they were restricting their right to be selected only under the Hyderabad category.
Yes.
Now that by that process, my lord, a candidate who is selected under the non-Hyderabad category will be ousted.
Yes.
Because they are coming in. And I will be ousted, and some other candidates will be selected under the non-Hyderabad category, my lord.
Yes, that is what the reservation is.
Yes, my humble submission is. Previously, this was not the situation which the KPCL has done it, my lord. They have given clear option for the candidates. Only who has applied under the Hyderabad Karnataka was allowed to go there, and he was never fitted into the north.
That was there. Then I think they have given a representation and all government has considered. Unless you say that that is wrong or illegal, then you can't. There may be earlier that was the procedure adopted. Maybe some other cases we have seen that. Therefore, after that, they have given a representation and all government has reconsidered to give this method. Unless that method you show that it is illegal, I think there is no bar for them.
No, because it was never an issue. It was never notified in the notification, my lord, recruitment notification, that we are going to change the criteria regarding how to be the non-Hyderabad Karnataka candidates and the Hyderabad Karnataka candidates will be included in the same list simultaneously without there being any option anta ellu helilla in the notification. They have changed the rules of the game.
Get that they are doing.
Suddenly, after all the Supreme Court judgment, my lord, they are now saying after the selection process is
even then that there is two different examination has to be conducted. That he has pointed out that because whatever that recruitment notification process is completed, government said you go ahead with that. Subsequently, you have to do it separate.
Yes, what they are saying to say is
they will answer.
No, they are not saying, my lord, that they will do it separate. What they are saying is ಉಳಿದವರನ್ನ Hyderabad Karnataka ಹಾಕ್ತೀವಿ.
That is maybe general circular is their government.
That is what. These are the earlier also 3 times they have done the same thing, my lord. Whatever earlier that Hyderabad Karnataka and non-Hyderabad Karnataka candidate should be selected separately anta enittu. Same thing they have conducted. No, suddenly what was the need for them to do it? Because I was ousted from the list, my lord.
Some cases it was been argued.
Yes,
I think in Gulbarga itself,
please.
saying that I think government circular or something has been issued after being that they are being denied.
Yes.
In referring to that some Supreme Court judgment, I think they have made it. Let us see how that AG will answer because he knows.
And the judgment which my learned friend has relied upon, my lord, the same judgment I am also relying upon to the extent, my lord, that the rules of the game has been changed. Even though there was no direction by the Supreme Court to hold the Kannada examination, they have conducted it. And there it was descriptive paper.
Preliminary objection is that who are you?
Because my rights are affected, my lord. Because of that, I was selected rank number 9. Because of that method of recruitment, that method of examination, number of candidates who were supposed to pass the Kannada examination, they did not pass it, my lord. And I was put into the top ranking list. I was selected there, my lord. Now, because so many non-Kannadigas have written the examination in objective manner, those who have scored even 9, 5, 10 marks, now they have scored 80, 70 marks, my lord. That itself has changed the entire matrix of the game.
Your merit will be assessed in the written test. They are only passing to come inside that
Yes.
they know the Kannada. You have to be compete with them that written test which you want to delete them before that.
Why I am saying this was, my lord, this is very important, in my humble view.
Very important for your
For me,
eliminated
for one reason, my lord, if the harder the eligibility, greater is the burden on the candidate to get the eligibility and then compete with the other candidates.
Yes.
Now that they have made the eligibility very smooth, the persons who are not eligible have become the eligible barely because they, even though there is no direction by the High Court or the Supreme Court, and they've changed the rules of the game by changing the descriptive into objective. That also they are not answering, Lord, because it is not the subject matter which allows them to change the descriptive into objective type, because the C&R rules which they are relying upon itself points out to SLC pattern, my lord, the Kannada examination regarding SLC pattern. SLC pattern, they have followed all these earlier 3 examinations. Now suddenly they have given a go-by to that, and they are saying, my lord, that we have to write it in objective manner and you are eligible. By that method, my lord, I was at the top list, and number of people who are not eligible have become suddenly eligible, and they have thrown me out of the list, is my humble submission. That, therefore, I have a right. My right subsists till the entire selection process is completed. I have a locus standi to challenge it, is my humble submission. Grateful, my lord.
Yes. Yes, Mr. You are there, Mr.
A small submission, Lord. I am before your lordship on 2 grounds.
Now, which is your petition?
But it will be 573 of 2026. 27.1. Lord, I will not, Lord, trouble your lordship, my lord, repeating facts which my other friends have already, my lord,
Yes.
brought to your lordship notice. My lord, you are the engineering graduates, my lord, who are eligible for being appointed, my lord, as engineers as called for by, my lord, the corporation.
Yes.
They applied for, my lord, the post, respective posts,
Yes.
my lord, to their qualification.
Yes.
And my lord, they my lord, attended, appeared for the test, my lord, which was conducted in the year 2018.
Yes.
That is pursuant to the 17 notification. My lord, your lordship is aware that that examination was, my lord, cancelled by the
Yes.
corporation for the reasons, my lord, stated therein.
Yes.
And my lord, thereafter, my lord, the modified notification was issued, and my lord, in the 2018 my lord, examination was conducted in 6 centers, my lord, to cater the needs of the candidates who, my lord, spread over the entire state. To accommodate them to, my lord, appear to nearest to their place, my lord, 6 centers examinations conducted. My lord, the second examination, that is, my lord, in 24, my lord, was conducted only in Bangalore.
Yes.
Only in Bangalore. We could not appear, my lord, for 2024 examination.
Yes.
We are not challenged, my lord, earlier the notification or other examination, etc.
Hmm.
My lord, your lordship is aware that, my lord, the examination conducted on 1824 was challenged before learned single judge, which was dismissed, and ultimately, my lord, writ appeal was allowed, my lord, on the ground of negative marking.
Yes.
My lord, your lordship is aware of that. My lord, in my writ petition docket, my lord, I invite my lordship to page 103. Page 103, that where your lordship would get the operative portion of, my lord, the order of the division bench. My lord, writ appeal, the first one, my lord, writ appeals are allowed. Single judge order so and so is set aside. Next, notification, the modified notification, score list, etc. hereby caused. 1 to 3 are hereby directed to conduct re-examination. This is important. My lord, I want to put emphasis on this. Re-examination expeditiously and within reasonable time for all candidates. My lord, this is important. Appeared in the examination on 18/2/2024, pursuant to the notification dated 3/8/2017. Lord, it is the direction is very clear that it is, my lord, the re-examination is, my lord, confined to those candidates who appeared for the examination conducted on 18/2/2024. This is the specific order passed by the division bench. This order of the division bench was challenged by way of a special petition before the Honorable Supreme Court, page 105. So one Manjunath and others.
Yes.
But of course, my lord, this special petition was dismissed. But certain observations are made. Page 106. Page 106. Para 1, page
Yes.
106. We are not inclined to interfere with the impugned judgment and order of the High Court. Hence, special petition dismissed. Next, madam. However, we direct that in the retest that has to be conducted as directed by the High Court. Well, this is important. All the candidates who have taken the earlier test since quashed shall also be entitled to take the retest. If any candidate due to passage of time has become age barred, the same shall not operate as a bar for consideration of the candidature for appointment. Lord, the para 2, my lord, this is important. According to me, the Supreme Court wanted to, my lord, see that all the candidates who appeared for the test, the first test, my lord, which was cancelled, shall be given an opportunity to, my lord, write the retest that would be conducted by the corporation or CET. Lord, your lordship, I invite your lordship attention to Annexure B, my lord. Annexure B, page 41. In the first test, my lord, the second, this is 18/2/2024, the examination conducted.
Page.
41, page 41. Is a table showing.
Yes.
Annexure D, page 41. The title is a note, your lordship.
Annexure C.
D, my lord.
Page 41 is C.
Next page, my lord.
Annexure D.
Yes. Note, your lordship. About 56,000 candidates were eligible to appear for the return state. Out of 56, only 18,732 candidates have been appeared for the return state held on 18/2/2024. The reason being, my lord, in most of the cases that the center is only in Bangalore center. Earlier, my lord, they conducted in 6 centers. So therefore, some candidates they could not, my lord, know about this and appear, my lord, by traveling to Bangalore. Therefore, my lord, and out of them, the rest of it may not be necessary. Now, what I submit to my lord is, my lord, pursuant to this, my lord, we have uploaded our credential to their, my lord, official website that they accepted. But only, my lord, 2 days prior to that, our admission ticket, my lord, that website was closed to us. From the, my lord, the direction of the Honorable Apex Court, my lord, it is clear because, my lord, if they wanted to allow only candidates who appeared the, my lord, 18/2/2024, there was no need for the Honorable Supreme Court to make this observation because I have read the direction issued by the division bench. Division bench categorically in a, my lord, language, Milord, said that only those who have written, Milord, appeared for 18-2 are, Milord, entitled. If that is so, there was no need for Honorable Supreme Court to make this observation.
They have reiterated.
Yes, no, not reiterated. Next sentence, if any candidate due to passage of time has become age barred, that is because, but 18 is, Milord, the
That is
test.
there. They have not denied.
18, otherwise, Milord, from 25 to 20, there is no question of using this, Milord, passage of time. Passage of time means it is little longer, not 4 or 5 years.
No, now on the basis of the age, anybody is denied.
Because they have confined this retest as directed by the division bench to those who appeared in the examination held on 18-2. You were not given opportunity at all.
You have appeared in 18-2.
No, we have not.
Then how can
We have not. That's why, Milord.
Now, what is that Supreme Court said?
Supreme Court, that's why, Milord, para 2, page 106. Para 2, your lordship can see.
Yes.
However, we direct, Milord, after declining to, Milord, interfere in the order of the division bench,
Has to be
the
conducted
Supreme Court
as
makes
directed by the
observation
High
as per
Court.
para. However, we direct
Earlier
that
test.
in the retest that has to be conducted as directed by the High Court, all the candidates who had taken the earlier step since past shall also be entitled to take the
The
retest.
candidates who have taken that earlier test.
No, if earlier test means there is clear direction by the division bench, there is no question of Supreme Court saying anything. My lord, I have read it. The respondent
See,
23.
you forget about that. Now its Supreme Court order is that ultimate. What Supreme Court said, all the candidates who have taken that earlier test,
No, earlier test means, your lordship kindly see,
Yes.
earlier test
who
means.
was not eligible earlier, again they cannot be given
No,
permission.
my lord, if there was no occasion for, my respectful submission is, there was no occasion for Supreme Court to make this observation. If they want, because they have confirmed the order of the High Court saying that we decline to interfere in the order of the High Court. Still, my lord, they wanted to make certain observation, my lord, that is to say that all candidates, because your lordship kindly see, 18 examination was attended.
Adrna yen artha heli, who had taken the earlier test.
Earlier test, my lord, that may be correct, earlier test, since past, shall also be entitled. My lord, shall also be means, along with the candidates who appeared for 18 to 2024.
Don't be interpreting that judgment.
No, my lord.
Yes,
But otherwise, your lordship kindly see, otherwise, there was no occasion for the Supreme Court to make it. They should have left it that, saying that we decline to interfere in the order of the High Court. That is sufficient because the direction issued by the division, kindly, my lord, 103, my lord, kindly see that the direction is very clear, there is no ambiguity, there is no need for Honorable Supreme Court to make the observation because the, in the order portion, my lord, point number 3, my lord, it is respondent 1 to 3 are hereby directed to conduct re-examination expeditiously within reasonable time for all candidates appeared in the examination on 18 to 2024 pursuant to the notification dated 3/8. If this is the, my lord, order, and when Supreme Court said we don't want to interfere in the order, why, my lord, this observation? This observation is only to see that, my lord, all the candidates who appear for the test conducted in the year 18, otherwise, my lord, your lordship see ultimately we have to interpret based on, my lord, the language couched in the order. Kindly see, my lord. Also be, shall also be, means along with those who appear.
Also who has applied. Who has applied. You are all applied for that.
Yes, we have applied and appeared, my lord, 18 examination conducted in the year 1918. 18 we appeared. That was cancelled. 24 we could not. Now the Supreme Court says, my lord, who had taken the earlier test since court shall also be means with the candidates who appeared.
Yes.
For, my lord, the examination which was passed.
Yes. You are going back to that one exam early, which has been cancelled by that
Cancelled is by the corporation itself.
corporation.
On the ground of some malpractice, something like that.
You-
Anyway, that was confirmed. That order is confirmed. I don't want to say anything on that.
Yes.
But, my lord, because of this para 2 and 3,
Yes,
in the
yes,
order
yes.
of the Supreme Court, my lord, the intention of the Supreme Court is to allow all the candidates who appear for the test which was cancelled to write the, my lord, the retest that would be conducted as directed by the division bench.
Yes,
Yeah,
let us
that
see
is,
how
that
they
is
will-
not myself.
Yes.
Another one, we have stated so many
No,
repetition.
which date you have taken examination?
On first, which was cancelled, that is 21/1/2018.
Yes. Yes, that's all.
We have taken a ground, in the petition itself. There is no counter, denying this. We were allowed to upload our credentials by the corporation. 10 tickets were denied.
Yes,
They have closed the website to us.
Yes.
That's why we could not appear for
yes,
examination which was conducted as directed by the division bench.
yes.
But only 2 days prior to examination, they closed the website.
Yes.
That's why we could not. Otherwise, we have uploaded all our credentials.
Yes. That's all. Yes.
Just answering my learned friend Prakash Manoj, the objections are ready, we'll file it by tomorrow, Manoj. In the second round of litigation, that's the second examination, Manoj.
Yes.
The learned friend's clients were not parties to the proceedings because they're not written the exam.
Yes.
So there are two things. First was withdrawn, Manoj, as a lawsuit. Only thing which was quashed is the second exam. The
Yes.
Supreme Court clearly says people whose examinations were quashed or written, they are eligible. It doesn't take back to the first examination which was cancelled.
Yes.
So therefore, my lords, it doesn't revive an existing right which has already given a closure pursuant to the first examination, my lord. This is again just a game of chance, my lord, where they're trying to say that by what Division bench or Supreme Court, they're a party,
Yes.
neither taken the examination, they have a vested, they have a right accrued.
Yes.
And one more thing, the age relaxation is only given, all those things have been given only for those who have taken the second examination. I'll just read this. We direct that the retest has to be conducted as directed by the court, High Court. All the candidates who have taken the earlier test since quashed. What is important is only regarding the quash shall also be entitled. So and so. If the candidate due to passage of time has become age barred, the same shall not operate as bar for consideration of the candidature for appointment. That's very clear, man. So therefore, it doesn't say that people, the examination which has been cancelled,
Yes.
they are entitled to, Malos. Insofar as, Malos, the petition with regard to Hyderabad-Karnataka, Malos, that is what is.
No, that you give that reply to that Santosh Nagarala case.
Please, Malos.
Because these are all only 2-3 grounds. Then we will go to that
Please, Malos.
final reply to that. Which
In that 2 grounds, Malos, in this matter, that is first. There are 2 issues in that Santosh Nagarala's matter, Malos. One is regarding Kannada, Malos.
Yes.
If your lordship may kindly see that petition annexure B, clause 8, Malos. What is required to be done in that as per clause 8 is he needs to pass the Kannada examination, Malos.
page.
The page is annexure, which petition? Yes, WP number 953, Malos.
Yes. Yes.
That is page 40, Manos, clause 8.
Yes.
What was read out to your lordship, Manos? Kannada language test. What is important in this? No, this is. So, okay, this is the. Your lordship may kindly see this, Manos. Those who have not studied Kannada,
Yes.
as one of the subjects in the SSLC or equivalent examination are required to pass Kannada language test.
Yes.
And then candidates who pass the Kannada language test are only eligible for consideration for the selection test.
Yes.
So therefore, my lords, my first preliminary submission to this is, my lords, the writ petition is not maintainable at all, my lords.
Yes.
For the simple reason, my lords, he need not take the examination because he has studied Kannada examination
He is not an aggrieved person of that class.
under this.
Yes.
And his grievance is like a thing, my lords, if they become eligible, it is not eligible, then they'll become more meritorious. So I don't want other people to be eligible, and
Yes.
so therefore, my lords, any person who can be aggrieved by the test conducted or any error is a person who has taken the test under clause 8.
Yes.
Either saying that the earlier test, you should have taken my earlier test marks
Yes.
pursuant to the High Court order, or you could not have conducted a retest,
Yes.
or on the ground that it is multiple choice and descriptive answers. So therefore, my lords, the
Yes.
candidates who have taken the test under clause 8 are not before the court. When they have no grievance, my lord, at the instance of the petitioner, this petition is not maintainable, my lord.
Yes.
In so far as Hyderabad-Karnataka, my lord, I'll just point out that while replying to that, the various judgments which this court has dealt with, my lord, were recruitment, my lord. The notification of 2025 is a clarification of the 2016 notification, my lord. It only says that, my lord, like scheduled caste and scheduled tribe, my lord, saying that if Hyderabad-Karnataka students are available, my lord, they go on the merit list for non-HK region, then leftover will go get filled up in HK. So therefore, my lords, to say that then there are conflict and produce those judgments which this court has dealt with similar issue, my lord.
No, he is saying that they have to conduct two different examinations.
No, examination is the same. What he is trying to say, subject to correction, when you fill up an application for HKE region, you cannot take selection in the non-HKE.
First, he is saying that examination has to be conducted separately.
So writ petition, I don't think that's a contention, my lord.
Yes.
But
That
there's
is-
one single examination.
No, that your government circular says it should be separate. That is what he has read out. You come to that annexure Z1.
We'll clarify that, my lords, with regard to this 16th circular has been subsequently that has been modified with 3625, right? Clarified, my lords.
Yes.
Page 235
WP.
WP 232.
In fact, my lords, I'll come back to that and clarify that with
Yes.
regard to the June 2025, clarifying 2016,
Yes.
which is raised in my learned friend Nagaraj, Santosh Nagaraj.
No, that
When we got it only yesterday, my lord, we'll just.
no. In 2328 of 2026, annexure Z1, where your director has issued saying that he further clarified that notification dated 3/6/2025. Accordingly, both notifications are applicable to that examination scheduled to be held on 27/12/2025 and 28/12/2025.
Yeah, 233 previous papers.
Yes.
I'll get back to that, Manoj. To be honest, Manoj,
Yes.
not have to get proper, correct information. But so far as saying that mode of selection, not the test, Manoj, this court has already dealt with it, Manoj. Then coming back to other contentions, Manoj,
Yes.
can I give a note which has been prepared, Manoj?
Now that Lakshmi Narayan and Murthy, you can take some other date instead of waiting. Friday, bada. Friday.
Friday. Have it on 11th, my lord, Wednesday.
11. Yes, 11.
12 one,
12th. Yes, 12th. Yes. Which date you want? ಸೋಮವಾರ ಮಂಗಳವಾರ ಅವರು ಇರ್ತಾರೆ 11th or 12th? 12th. Yes.
Serial number 28.
No, I think your matter will be reached before 12 because it is the first in that B group. Today, otherwise it would have been reached as 12:30 itself. Mm.
But the effect of your lordship's order is going to be one prescribed in share eligibility.
Yes.
Those engineering medical college unaided.
Yes.
Whether class for employees are paid by the pay scales of state government are not easily purchased.
I thought on that day, 4 o'clock. Yes.
Last week and the Supreme Court has said, whether you are earning profit, whether you are earning loss, you should pay the state sales. All state governments have been asked to pay an affidavit. So as Karnataka, they took that.
I will see. I don't know. I've forgotten what is the case and all. On that day, we'll yes recollect. ಹದಿಮೂರಲ್ಲ 12. No, you do one thing on 12th at 2:30. 12th 2:30. 2:30 it's huh? Yes. 12:30. Then we will know that 18th.
What I am offering to my understand, 4 o'clock from the start, let him not come here, but let him be there. In office, next day,
He is also saying that. No, he is concerned about you, but he is not concerned about the court. See, if I am in that, yes. See, like this matter, I am in that middle of that in the 4 o'clock. Either I can't call your matter or I will not complete that. That is what that Narsimurthy is telling. 2:30 we can give in a break. 2:30.
4 o'clock.
Yes, let us see at that 4 o'clock. Yes. 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 4 o'clock. Yes, on that day, if he's not, you can give in some other day for you if it's concluded. Yes. Yes. Yes.
February 2014, 13th February 2014 and 20th April 2014. It is one of the totally important is take case number 7 for a moment. Case number 7. Sanction strength, my lord, is 1742.
Where you have mentioned?
That is page 7, end of page 7, my lord.
Yes, 1742. Yes.
Number of posts filled up by the law of recruitment in 2014, that is first stage. Your lordship, one of the argument was argued 2 stages it should be.
Yes.
So first stage was, my lord, 650.
Yes.
Second stage, which is the subject matter now before your lordship, is the second stage, my lord.
Yes.
Number of posts for recruitment was conducted for 622.
Yes.
In that, my lord, the total number of candidates who wrote is 6482, my lord.
Yes.
9482.
Yes.
9482, I'm sorry.
Yes.
So therefore, my lord, insofar as what has been quashed by this court is insofar as 9482 is concerned.
Yes.
Of second stage, my lord.
Yes.
So therefore, my lord, in spite of having filled, if you fill 622 also, my lord,
yes,
there will be a further vacancy of 470. The
yes,
point I'm trying to make is, my lord, and this has been going on from 2014 to 2026, past 12 years. This is the third round of litigation and third examination.
Yes.
So therefore, your lordship, this is the basic facts, my lord. Then your lordship will get page 1 and page 2 is the first examination which was held on serial number 4, Malot, on 21st January 2018, Malot. Then, Malot, we withdrew the examination due to certain malpractices. Writ petition was filed to direct to continue with the examination. Then this court dismissed the writ petition and writ appeal, and the matter went up to Supreme Court. Our cancellation was upheld, Malot.
Yes.
Then the second round of litigation at serial number 6, second examination is at serial number 16, Malot, page number 4. Page number 4.
Yes.
I just put the heading as second examination, Malot.
Yes.
Multiple challenges, Malot. Re-examination was considered. Final score was published serial number 17 on 18/5/2024. Public provisional list was thing, Malot. The most important, Malot, in this, 1/3 negative marking was given. What is important is, Malot, the original notification 2017 did not speak about negative marking. It came only in the hall ticket. So out of 9,000 and odd, Malot, around 25 people went to the court saying that we did not know about this negative marking out of all the numbers, Malot.
Yes.
Court said, was it part of the, not the C&R rule does not speak about it. Your notification does not speak about it. At the last moment, people might not have read your hall ticket. So you're not informed much earlier to these people. I'm sorry, I stand corrected. Because we are in the first exam, we had mentioned the hall ticket. Second examination, we are not. This examination, we are also not mentioned in the hall ticket. We presume that they had knowledge. Court said that neither in your 2007 notification or in your hall ticket. So therefore, on that ground, Malot, it was quashed. I'll point out to the division bench judgment, Malot, to show that the examination was set aside by the single judge, confirmed by the division bench and the Supreme Court. And the review petition also came to be dismissed, Malot. Now, in the side in Dharwad High Court, Malot, what your lordships read, Honorable Justice Mugdum judgment with regard to Karnataka examination. There also, Malot, the short point in what Rule 8 and Clause 4 point says that, Malot, he has to pass the examination. To pass an examination, there should be a minimum criteria, unlike for others. So if you're saying conducting a march for 150, or you should tell it talks about 100, then you should say what is the minimum mark so that he knows while going what should he score. So therefore, again the point number 3 in that judgment was put them in notice. You find out what it is. You do it after telling them. The whole point in both the cases with regard to negative marking or Kannada, prior notice, no information was given to them. I'll just point out by reading the those two judgments. Ultimately, Malaz, what is the direction issued to us? Is implement the 2017 notification. Supreme Court says do it within 4 months. We have strictly complied with the 2017 notification, Malaz, and we have held the examination within 14 months. So the only, now coming to answering the grievance in the written submission, which I'll just answer the written submissions with written note given by my learned friend, Malaz, one by one, so that it, Prithvish has given, so that it's not, where is it? Okay, I've got it here. Your Lordship may kindly see dispensing with minimum qualifying marks is illegal, Malaz. If your Lordship sees first point, Malaz, A, in this summary of contention, Malaz, my learned friend, summary of contention, Malaz. Page 1, Malaz, first page, summary of contention. Not mine, Malaz, my learned friend's. So I'll just reply to my learned friends. Summary of contention, contentions, Malaz. Is seeking to challenge the 2025 publication for holding the examination. He doesn't challenge the 2017 notification, and he cannot challenge also because
it's concluded by Supreme Court.
And there's a positive mandamus to do it as per that. Now the question is, he's not able to point out that we have violated the 2017 notification. So So therefore, he has said not challenged because we are bound to imply, he has not challenged that. And all these people, and these people are the same people who have taken the person to the 2017 notification.
Yes.
Because it is quashed. So therefore, my lords, neither when the test which was conducted, the previous examination and this examination, there's absolutely no change except for the point, my lords, when so far as negative marking is continued because we have put them on notice as per the division bench judgment. What we introduced is, my lords, sometimes what happens while 4 choices were given, they used to say because of negative marking, my lords, the person does not know the question. Sometimes because OMR sheet, my lords, is not very clear as to whether they have marked or not marked.
Yes.
So what we gave a 5th column. I don't know this answer. So that no negative marking in the interest of the
Yes.
candidate, saying that you put this, make a 5th choice so that you do not get
That confusion will not arise.
that confusion. So therefore, my lords, whatever we did, the question is no prejudice is caused to the candidate. It is in the interest of the candidate. It's not, question is you can find fault. The question is what prejudice and this is caused. So therefore, my lords, and going by again the second 3.33, my lords, this says where written examination, can I permit you to read 3.3, my lord?
Yes.
I'll just read it. Your Lordship need not go through it, my lord. The only point here is, that is at page 144.
Yes.
Your Lordship may kindly note the page number. For the written test to be conducted, the MD will nominate the authority to conduct the written test, specify the minimum marks for general category with the relaxation of 5% for SC/ST candidate.
Yes.
That is one aspect of it. Second is, such of the candidate who pass the written test will only be appeared for Viva OC subject to Rule 3.34. So therefore, my lords, however, where written test is conducted in relation to the post of specified services, the Visa OC will be limited to the ratio of 1:5.
Yes.
So therefore, admittedly, my lords, nobody is agreed.
Yes.
Here saying that, my lords, earlier also there was first, second test, there was no Viva OC.
Yes.
Nobody's case was you have violated 3.3 and conducting the test. So minimum marks will arise, or this condition will arise only when you are saying that
Yes.
these candidates are allowed to be taking for, unless you get a minimum marks of this, you are allowed. Here, it is strictly on the basis of inter se merit,
Yes.
either for scheduled caste, scheduled tribe, or for the general category.
Yes.
For example, Manoj, if assuming in the worst scenario, there are 100 candidates,
Yes.
100 seats for general category. If I put a minimum mark of 60, if only 40 come, then we are failing somebody.
Yes.
Here, what we are saying that we are going to make number of candidates seniority
No, that intention is that all posts has to be filled.
filled up, and we have got another 470 to be filled up in future. And past 2014 to 2026, no vacancies has been filled up nearly for 12 years. So therefore, my lords, again going back to the point,
Yes.
how is the petitioner prejudiced or affected by not prescribing the minimum marks? And second point is 3.3 applies only when Viva OC is to be conducted. And all these candidates had knowledge, my lords,
Yes.
that there was no minimum marks. Oh, therefore, my lords, misplaced sympathy, saying that in the name of scheduled caste and scheduled tribe, we are not, as if we are not given them the benefit because they'll get affected. So it's well, we got a separate list for them on those people, number of candidates. We'll fill them up. If they're merit, if they're come in general merit category, we will fill them up in the general merit category. Yes. So therefore, to say that we have not fixed a minimum, then giving them, it's like saying, put a number, delete minus so much, then give plus marks. Need not be done.
Yes.
Well, that is point number A and B, my lords. HK, my lords, I'll just come back to that, my lords.
Yes.
Page 2, serial number 3, my lords. C, my lords.
Yes.
Merit list based on written examination and ultra virus, which also, so therefore, my lord, A, B, and D are the same points, my lord, which I just made.
Yes.
Then I need not answer. So therefore, my lord, I'll have to get back to your lordships only on point number C, my lord.
Now that you have to answer, what is that C&R?
My lord,
How it has been framed? What is that effect?
your lordship
Where is
may
your
kindly
power
see
to
one.
frame that C&R?
Well, so therefore, both the judgments, my lords, which division,
Not answered there.
they are not answered. They have also said not, even though they have not said whether it is binding or not. They have answered in saying that you put them on notice and you can go ahead, in spite of it not coming in C&R rules.
See, your is the board.
Correct, my lord.
It is board is created under which statutes?
That is under the Karnataka. Board is created under the Karnataka KPCL Act.
No, how that board has been created under which statutes?
There is no statute. It is not created as it was a department of the PWD. It's got bifurcated and created as a company under the Companies Act. It is not a statutory corporation.
It's a company.
It's a company.
Then what is that service conditions and all of the employees of your company?
There is a
Board fixes. Under the articles of association of the company, board has
You have that articles of association.
not placed, not on the record. Now.
Also, that is the point where you will get this power for
And
you may
passing
call
the
it
board
rule.
resolution or to do the C&R rules where it is.
It is like any other company.
No.
It is like
No.
any other company.
No,
You
if
have
it
to
is a
place it before
company, you have that articles of this thing. Under that, you have any power. What you can
So the
do?
board has the power to do everything.
No, we'll place it. We'll go through it and place it
Just
before.
go through
Lord.
and place it that.
I have not
Otherwise,
examined that, my lord. I'll look
Yes.
into that and
By reading that, it shows that C&R, you are using that same word C&R. What that normally using in that service
correct
matter.
service.
It's under either Article 309 or under Civil Service.
No, we'll just
Yes,
honestly we'll study that aspect and the Hyderabad-Karnataka thing.
Two is the major issues, yes, that has to be answered. Yes.
Can I request, my lord? My learned friends are not there tomorrow. Day after tomorrow, my lord.
Yeah, tomorrow, Thursday. Friday, no. Friday
Monday, can I
only for
request?
Monday. Yes, Monday at 2:30. You have there is no any.
Now they have become 3 tests they have already conducted for us. They are fully prepared.
No, you are keeping busy.
Fully occupied.
Yes. Let us see that. Yes. Yes.
I just got a copy of the full rules, of course, not the schedule of it.
Yes. Good.
And the only thing is that I just wanted to show you a lot of it. Of course, it looks like it has all the trappings of a C&R rules.
Yes.
Let's from the first chapter, Manoj.
These are all the employees who are working in that KPCL. They have been. They might have been advised to make this type of rules.
Yes, 1.3.1. They say 3.1. Manoj.
Yes.
These rules shall apply to all persons appointed and to be so appointed. So even for recruitment, Manoj, this follows. And last one, Manoj, repeal and savings. They repeal rules of 1992. 20.1 KPCL cadre recruitment probation rules 1992 are hereby repealed. So probably, Malad, we'll have to look at the 92 rules to see the source.
Yes.
Yes.
Yes, that we'll see. Yes. Summary, please. Impleading applications, you can argue.
Let's barred by res judicata because earlier round impleading was not allowed. No, can't be. No successful, no select list only.
No,
Yes, they can file appeal and
see, if I hear and the application is allowed, challenging that and all, instead of that, this is what are the questions you can also argue. Even if that order goes against you, you can file an appeal. There is no bar. Why you want to be impleaded? You want to be impleaded to argue the case, I will permit you. Or if you go against that, you can easily file an appeal. Instead of that also, you can file an appeal. Let us see. Yes.
Yes.
That's right. Let us see. Yes. Pastor.
Pastor matter. Serial number 5, A. Nagarajappa, packet matter.
Excellent. It's an order of suspension.
Yes.
We have complied the orders, Your Lordship.
Yes.
Impugned order, Your Lordship will find at page 31.
Yes.
Annexure F. At the operative portion of the order.
Yes.
Lordship at page 33. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಕಾರಣ ಮೇರೆಗೆ.
Page.
Page 33. Internal page 3 of the annexure F.
Which case?
My lord, 3089.
3089. Page 33. Yes.
ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸಿರುವ ಕಾರಣಗಳ ಮೇರೆಗೆ ಕರ್ನಾಟಕ ಸರ್ಕಾರಿ ಸೇವೆ ವರ್ಗೀಕರಣ ನಿಯಂತ್ರಿಸುವ ಅರ್ಥರ ನಿಯಮ 2ರ ಉಪನಿಯಮ ಮೇರೆಗೆ ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸಿ ಹಾಗೂ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ UDD 104 2014 9/1/2000 ರಲ್ಲಿ